The title of this presentation is Appraising the Appraisal Remedy. Is it really the best option for dissenting shareholders? Appraisal provisions give dissenting shareholders the right to demand payment from the corporate issuer of their shares at a fair cash value. The aims of appraisal include compensating the minority for loss of veto power, offering cash exit for them as opposed to forced membership, protecting the majority by expediting corporate transactions. There are several instances where appraisal may be used. They include in mergers and consolidations, schemes of arrangement, substantial transfers of assets, amendments to a company's articles of incorporation, dissolutions, liquidations, and conversion of a company's status from one firm to another. Appraisal is available in several jurisdictions, but this discussion will be limited to the United States, New Zealand, and South Africa. In the United States, Chapter 13 of the Model Business Corporations Act provides for appraisal. The remedy is incorporated into statutes of all U.S. states, which mostly take cognizance of the provisions of the MBCA. Instances in which appraisal rights may be invoked are mergers, share exchange, disposition of a company's assets, amendments to the company's articles, domestication, conversion of a company's status to non-profit, and conversion to an incorporated entity. The procedure in the US is this. When an appraisal triggering transaction is planned, the company notifies shareholders of their rights. The dissenting shareholder must then not vote in favor of the transaction. Then certain statutory formalities will be completed by both parties. The company makes a cash payment to the dissenting shareholder within 30 days, which is the estimate of fair value and interest. Appraisal in the US can be used deliberately to force out the minority, and then it also has valuation problems, although changes have been introduced to correct these problems. The procedures are also cumbersome, discouraging dissenting shareholders. The MBCA is also meant to act as a guide. Hence, state provisions could vary. For instance, state laws could limit transactions that trigger appraisal to just a few of those recognized under the MBCA. In New Zealand, sections 110 to 115 and 118 of the Companies Act provide for appraisal. Instances in which appraisal rights may be invoked are adoption, alteration, or revocation of a company's constitution, approval of a major transaction, amalgamation, and liquidation. The majority agrees on any of the above transactions, and the dissenting shareholder requires purchase of his or her shares. The board must then respond within stipulated time limits. The Act requires that the purchase price be fair and reasonable. If the dissenting shareholder objects to the proposed price, the matter goes to arbitration. Meanwhile, the company pays the provisional price, while the balance is to be paid later with interest. It's also interesting to note that under the Act, a third party is allowed to purchase the dissenter's shares. In New Zealand, previous problems experienced under the appraisal regime include that there was insufficient guidance on valuation and timelines. The basic requirement of fair and reasonable value was not very helpful. For this purpose, the Company's Minority Buyout Rights Amendment Act of 2008 was introduced to address these problems. It reduced time for the board's notice to 5 working days. Although the Act retained the previous valuation method, introducing the option of a different valuation method where the former will be clearly unfair to either party was an improvement. Also, requiring the board to give details of how valuation was done promotes transparency. Providing for arbitration is also a positive development. However, the company could unduly prolong the offer process since it acquires legal title to the shares on the same day that it gives notice of its offer to the dissenting shareholder. Also, Sections 114 and 115 constitute a limitation to the dissenter's rights to appraisal, as they exempt the company from purchasing the shares in certain situations, although this may be mitigated to an extent by allowing third parties to acquire the dissenter's shares. In South Africa, appraisal rights was introduced by the Companies Act of 2008. Instances in which appraisal rights may be invoked are disposal of all or the greater part of the company's assets or undertaking, mergers or amalgamations, a scheme of arrangement. The procedure is this. The dissenter gives notice of intention to demand for appraisal before the company passes the appropriate resolution. The company must respond after it adopts this resolution. The shareholder then demands a fair market value for the shares and thereafter has no further rights in respect of these shares other than to receive payment. The company must pay up within 10 working days. The company must offer an amount it considers to be the fair value, with a statement showing how that value was determined. If no other offer is made, or it's an inadequate one, the dissenter can apply to court for determination of fair value. In South Africa, appraisal is still relatively new, thus it's too soon to tell how effective the procedure will be. Directing payment to dissenting shareholders within 10 working days of the acceptance of the company's offer is meant to ensure a speedy process. However, the court's ability to vary this provision if the company can show that doing so could result in its ability to pay its debts for the next 12 months is a potential problem for this remedy in South Africa. Also, directing payment at the earliest possible date compatible with the company satisfying its other financial obligations as the fall due and payable is detrimental to the interests of dissenting shareholders. The shareholders' right to apply to the court for determination of fair value empowers that shareholder, and awarding a reasonable rate of interest also favors the shareholder. However, beyond requiring the company to offer an amount it considers to be fair value, there is not enough guidance under Section 164 on a precise method of determining fair value. Hence, it is predicted that more recourse will be had to the courts than necessary on this issue. Appraisal fosters the idea of a win-win situation for both sides by encouraging an amicable resolution. The company is able to move ahead with the proposed transactions. The minority is compensated for loss of veto power. The procedure is expected to be done over a shorter period than other processes. It is designed to be cost-effective compared to other procedures, as it is not primarily designed to involve litigation. Also, any individual shareholder can pursue the remedy. The merits of appraisal include: it has the tendency to lead to minority freeze-out. In fact, it is sometimes deliberately used for this sole purpose. Then, determination of fair value is a major problem. Appraisal is also hindered by complicated and demanding procedural rules, which do not provide adequate guidance. In reality, it has a tendency to drag and can end up being a lengthy process, with some going on for years. The possibility of the company relying on lack of funds to frustrate or delay payment is also a disadvantage. Methods of valuation include the discounted cash flow method, comparable companies method, comparable transactions approach, net asset value method, and market value method. And a leading case on valuation is First Western Bank Wall versus Olsen, in which the court held that fair market value was an incorrect method of valuation. Alternatives to appraisal include personal action, which can be brought by an aggrieved shareholder against the company for wrong done to that member or a group of members. For example, where an act or omission is oppressive or unfairly prejudicial to the applicant's interests, the company's business, or the director's conduct has that same effect. The merits include that the reliefs under it are limitless. The procedure enables minority shareholders to challenge the majority's decision, and the primary purpose is not for the minority to exit the company. The merits, however, are that the relief is entirely at the court's discretion. It's only applicable in cases of unfairly prejudicial conduct. Thus, in the absence of fraud or illegality, members are stuck with the company's decisions. There is also the derivative action, which could be brought under common law or under statutes. There is also the private action, which is available to members in a private capacity for the enforcement of rights accruing in a private capacity and not as members of the company. Another alternative is an application for inspection of the company's books. The last one in this presentation is subjecting the corporate transaction to a business purpose test in court to determine if the transaction should be allowed or not. In conclusion, appraisal, though not without problems, has the potential to favor all parties. However, the fact that it means an end of the dissenter's membership is not to be taken lightly. Thus, a member relying on appraisal should be aware of its implications. Appraisal should be seen as a last resort after duly weighing all other possible remedies. It is recommended that appraisal be made available alongside other remedies. That way, shareholders will not see appraisal as the only workable option, and the majority will be less inclined to use appraisal solely for the purpose of edging out the minority. And then the references are on the last pages of the presentation.